If you're a business that is struggling to pay your debts, or you run into this in the future, you want to know about two different options that you have in the bankruptcy courts. Now, these have been used by many well-known companies over the years that have came out and survived when they could otherwise have faced financial ruin if they didn't use the bankruptcy laws. So I want to go over those two options here. First is a Chapter 7 bankruptcy. This is like the wipeout bankruptcy. If you're like, all right, I'm closing up shop. I owe a lot of people money, but I can't pay them. I don't want all my personal assets to be at risk. And in that case, you can file what's called a Chapter 7 bankruptcy. The upside to Chapter 7 is it's called a liquidation. The company is going out of business. You don't get to continue on with this business, but you get to wipe out all of your creditors. The company is not on the hook for anything. Now, the bankruptcy court is going to say, well, what assets does the company have? So if the company has equipment or trucks or computers or other assets, they're going to say, well, we need those assets. We're going to sell those to pay off the creditors as part of the bankruptcy process. Now, Chapter 7 isn't your best bet. That's kind of like, I'm waving the white flag. I'm done. Creditors, come and have what you may, but I don't have anything. And then you as the business owner, frankly, get to hide behind the corporate veil and protections, whether you've got an LLC or corporation, and all of your personal assets or other companies are not going to be at risk. But that business does need to wind down and close so it cannot move forward. Now, there's a huge caveat to Chapter 7 where you could be on the hook personally for debts that I'm going to come back to here in a second. But I want to explain the second option, which is what Forever 21 is doing, which is a Chapter 11 bankruptcy, also known as a reorganization. In a Chapter 11 bankruptcy, if your business cannot pay its debts, whatever's coming in for the business each month is not sufficient to cover the debts and obligations, you can go to bankruptcy court and file what's called a Chapter 11 and say, hey, we need to restructure our debts. We may owe $1 million that's costing us $100,000 a month to cover an expenses, but we only have $50,000 of income. This is not going in a sustainable way. So we are going to restructure the debts in bankruptcy. Now, what happens is you have to file a reorganization plan to the courts, and you have to notice all of your creditors and say, hey, I can't pay you. We got to reorganize these debts and come up with a payment plan. In most instances, those creditors are going to take a haircut of what they're owed. And on a going forward basis, you're going to have to pay any vendors or any contractors or people you pay, of course, what is agreed to, that any past due debts or obligations are going to get restructured into a payment plan.
Hey, sorry to cut in here. I just want to make sure you know of my law firm, KKOS Lawyers, where we help clients across the country save on taxes, protect their assets, and plan their estates. Get over to KKOSlawyers.com to learn more. We'd love to be of assistance to you. Now back to the video.
Now, the amount that the company's going to have to pay these creditors depends on what is the income and revenue of the business, what's your reorganization plan, and then it's also going to depend on, are these creditors secured or unsecured? Now, whether they're secured or unsecured is actually quite important. Let's say that the inventory in the business that you bought came from a vendor, and they have a lien on that inventory until you pay them. In that instance, they're secured in that inventory. They can take that inventory back from you so you can't sell it. It could be the same thing with any equipment you have in your business. There might be a lien on that and a secured creditor, the seller of that equipment to you, or maybe there was a bank that you got financing from to acquire that equipment. They might be secured and have a lien on that actual equipment. So they typically get paid first. They're going to have priority in the plan. Other creditors are going to have other areas of priority you need to think about as the owner of the business. For example, is this the landlord for where my store or office is located? I want to be there next month. I got to figure out how to work that out with them. Secondly, what about any vendors that are critical to your business? You got to figure out how to work that out because you may want their services next month to continue on. And if they take too big of a haircut in the reorganization, they may be like, use someone else next month. We're out. So you want to think through this. There's a lot of business decisions that have to be made. We got to look at who's secured and unsecured and the different priority levels of the creditors. Now, one of the big issues that small business owners have in bankruptcy is many times they have signed agreements in their personal name, or they have signed personal guarantees for certain things. For example, let's say the lease for your store or your office or your warehouse. Many landlords require the personal guarantee of the business owner because they don't want you to file bankruptcy in your company and say, you can't come and get me. They want to come after your personal assets. So if you've signed any personal guarantees, you are going to be personally on the hook with those creditors. Bankruptcy is not going to help you and save you in those instances unless you also file bankruptcy personally. So you've got to have a little carve out if you're thinking of bankruptcy of the debts and obligations situations where you may have signed a personal guarantee. And that's a really critical tip for any business owner is we're not planning to fail, of course, but if it does happen, you may need to use the bankruptcy laws to save your butt. And that's an important tip there for any small business owners. You want to be careful about making any personal guarantees, because if you're in the unfortunate situation where you have to rely on the bankruptcy laws for your company, you're going to be personally on the hook and have to personally file bankruptcy to get out from under those obligations where you have a personal guarantee. Now, we want to consider bankruptcy here if we absolutely have to, but it is a tool available to you in the law, so you might as well use it if you have to. Now, the determination here is, can I repay my debts or not? If it's really close from you being able to pay your debts based on the income of the business, or you see a future around the corner in a few months, do not be thinking about bankruptcy. The process, the cost of it is not going to be worth it. But if you are clearly upside down in the business, but there's still a future for the business and a path forward, if you can reorganize these debts, it will make sense to file a Chapter 11. That's what Forever 21 is doing in their case. They have a viable business, there is a viable brand, they've just got way upside down in their costs and their debts. And so the brand can continue forward, but they've got to reorganize, restructure their leases, I'm sure, restructure their vendor arrangements. Some of their creditors are going to take massive haircuts on what they're owed, and then there's going to be a plan moving forward. So it's a good example to think about for you, whether this is a one-store location or you have a service business, I don't care what it is, any type of business can use Chapter 11 to restructure their debts and move forward with a viable plan if you still feel like you have a successful business that has a future ahead where you can continue to earn income and revenue if you can get out from under the debts and obligations you've had in the past. Now, if you have to go down this path, the process is you'll need to hire a bankruptcy lawyer that specializes in this field, then representing businesses, doing a Chapter 7 or a Chapter 11. Typically, you're going to file that in your federal district court where you reside, and then there's going to be a notice to all of the creditors and people you owe money. They can't chase you down anymore. They have to wait for the bankruptcy court process to go through. Typically, if this is Chapter 11, you're going to have a reorganization plan and say how you plan to get back on track, what concessions you want the creditors to make in terms of what they're owed. There's a trustee in the process as well, and part of their job is to look at any of the assets, make sure that those can be used to pay back the creditors and that the plan makes sense. So in many ways, they're advocating for the creditors in the process. Now, the creditors might hire their own lawyers as well to try and make sure that they're getting paid and that they're getting advocated and prioritized in any repayment plan or any assets that may be sold or liquidated. And then at the end, there is a court order from the bankruptcy court that could be the liquidation and the company winds down, or the reorganization, and you determine who you're paying back and what you're going to be paying forward as the company moves forward in an attempt to succeed. Now, we don't want to file bankruptcy unless we have to. I'm all about paying the creditors and being a person of your word, but this is a tool that can be available to you to save a business. And many times, there's your family's future, there's employees on the line, there's other vendors that could otherwise be totally wiped out. So Chapter 11 can be a good thing overall to help a business that has potential succeed and make it through a difficult time. Now, please make sure you're subscribed to my channel. I'm giving you lots of tax and legal tips to make you successful in your business, tips on growing and building wealth. I'm Matt Sorensen. We'll see you next time.